Another edition of Dad's Divorce Live. Heather and I are here tonight. Joe couldn't be with us. My name is Angelyn Mitchell, and I'm an attorney in the St. Louis office. Heather is also an attorney in the St. Louis office. Her name is Heather Biagi. We're going to be taking some questions tonight that were submitted through our website. Just real quick, I want to say that we're both licensed in Missouri to practice law. We are not licensed in other states, and therefore if you live in another state and you have submitted a question, we'll answer as best we can, giving you some general information and hopefully answer your question somewhat. However, if you need more specific advice, you need to see an attorney who's licensed in the state in which you are living. That being said, we will dive right into the questions. And the first question that we have tonight is from Ruth. She is asking a question about her fiance's daughter. He's had custody of his daughter since she was very, very young, and she's now 13 years old. So he's had custody for about 10, 11 years. His his ex-wife rather is currently in child support arrearage of $11,000, and they have some questions as to how they can collect. The mother of the child lives in a separate state than the father of the child, and they are asking about why hasn't she been held in contempt. Well, one reason she hasn't been held in contempt is that there's typically not people just waiting for the arrearage to happen, and then they just automatically file a contempt action. That's something that you would actually need to bring, and you could file that. You would probably have to file in I believe she lives in Iowa. Since she would be the defendant, you would have to go to her, which would require that you likely would have to file the judgment and get the court to recognize that, and then file a contempt. Basically, having her held in contempt is simply stating that she hasn't complied with the judgment. The big problem with that is if she has the ability to pay the child support. If she doesn't have the ability to pay the child support, she can't be held in contempt, right, Heather?
That is correct.
Yeah. They're also asking about some criminal actions, and there are some statutes in which people can be held criminally liable for non-payment of child support. Again, you have that hurdle of whether or not they can pay and whether they've willfully been avoiding paying child support. And also, you would have to bring that to the prosecutor's attention because they're not sitting around waiting and watching the amount of child support that you're owed to file that. An idea that I have come up with, something that maybe Heather can help expand on, you might want to consult with the Iowa or the Wisconsin, which I believe is where you live, the child support enforcement agencies in those states. You might want to refer the action to them because they can help you collect. If she's working, a wage withholding order might help you collect. And Heather, can you explain a little bit about that?
Basically, as far as a wage withholding order, obviously, you would have to know where she works, and it is recognized once an employer does get it, they have no choice but to follow those guidelines and to take that money out of her paycheck. In Missouri, it's basically the total of child support plus up to 1/2 of the regular child support payment to count towards the arrearage. So if you have an arrearage, you can go after collecting not only current support but also that child support arrearage. Again, you're not going to get it in one lump sum. It's going to come in a series of payments. Obviously, they have to leave enough of the check for the person who's paying child support to be able to pay their bills and whatnot. But it is a way to get money, definitely get money. It takes you out of the equation. It puts the state as the collector, and again, employers have no choice but to take these monies out of the paycheck. The person has no right to say that they can't do it. If they wanted to say that wasn't the case, they'd have to go and file their own court action to prove that, and then that may solve your problem getting you into court in order to find out what that exact amount that is due. Like I said, the only way that it terminates is if they do change jobs. Unfortunately, if they change jobs, you will have to follow them to figure out what job they went to and then go ahead and file another one. That's basically kind of what sums up wage withholdings, and specifically in Missouri as to the child support plus 1/2 of the regular child support to count towards the arrearage.
Right, and child support enforcement agencies can help you do this, and they might make it cheaper for you. They sometimes will automatically file them when they notice an arrearage.
I'm of the personal opinion, if money is owed to you, definitely I think that's the first place to check into, simply because they do have a little bit more power. Obviously, they have a little bit more resources. A lot of times it does take a little bit more time because they have a lot of people that are going after child support for people. However, it again kind of takes you out of the equation and is of some cost benefit to you. If you're looking for actual quick adjudication or something that's a little bit more quick than it would be to file with the court and to go about it that way. Again, there's no promises that you'll get exactly what you want, but that's a little bit speedier of a way normally.
Absolutely. They're also asking about they would like to garnish a tax return for some of the arrearage. The problem with this, the mother of the child has remarried, and if she files a joint tax return, they can't really garnish that return because technically her current husband has absolutely no child support obligation with respect to this child, and to garnish that joint tax return would be basically holding him responsible, which there's no right to do that.
Absolutely.
Okay. Next question. This person is asking whether or not we have an attorney in Denver, Colorado. And I am happy to say that yes, we do. The attorney who works in Denver, his name is Ken McCrae, and your son can call our toll-free number, which is 1-866-DADS-LAW, and they will give him some information about how to set up an initial appointment and also setting him up a time for that. Okay. The next question is asking about custody of this guy's son. His ex-wife is a drug abuser who smokes weed in the house with the son. She has also attempted suicide. She apparently never takes care of the child herself and is often sending the child to her parents' house or the father's parents' house for child care. And the father also believes that she is bipolar. The son is 5 years old and apparently is very aware of his mother's drug use. The first question that I would have in regards to this is what the original custody order states and when it was entered. It sounds like you might have an action for a motion to modify depending on whether this behavior existed at the time that it was entered, and also you want to give some consideration to your own behavior. Certainly you can't go into court and claim that you have a right to a motion to modify because she's using drugs if you're also using drugs. Keep in mind that they can drug test you, and this sometimes means hair follicle drug tests.
Also something to keep in mind about